Welcome everyone to this quarterly presentation by Stretton Mason Lawyers in our Accounting Partnership Plus series about asset protection and bankruptcy. My name is Jeremy Stretton and with me is Craig Mason, and we're the legal practice directors at Stretton Mason Lawyers. Just a few things before we kick off. Just wanted to talk about us. So for anyone who doesn't know Stretton Mason Lawyers, we're a South East Queensland based law firm who have offices in Morningside and Caboolture, and we specialise in acting for small to medium-sized businesses throughout the life cycle of their business and provide advice to them in all facets of their business. What we do as part of these presentations, this is our seventh one, are quarterly presentations for accountants just about general topics of interest to accountants on topics that might be relevant to you guys. We want to make these as useful as possible, so we'll be sending around some emails with questions about how useful you found it in the next couple of days, and we really appreciate your feedback as to what kind of topics and that you want to hear. So today we've got some slides about asset protection and bankruptcy. I'm going to send through a link through the chat box. So if you've got that, you can have a look at the slides. Feel free to print them out if you can. Also, at the end of today, we'll send around a link to a recording of this webinar. We always do that for all of these, so that we have the resources. And if you're interested in any past topics, we're happy to provide that information as well. With questions, there's a facility in GoToWebinar to ask questions. Please feel free to do so as we go. We've got the screen open, so if you've got any questions, then we can help out and answer them as we go, or we'll have time at the end of each talk to ask questions. On that, I'm going to talk about the asset protection side, and Craig Mason's going to talk about the bankruptcy side. So, and once again, if you do want to ask any other questions later on, we'll send around an email. You've got our email addresses on this first slide. Feel free to email us with any questions. We're always happy to help because we want to make sure that everyone gets everything right. So the first couple of slides are just the business legal life cycle. So anyone who's new to these webinars would probably wouldn't be aware of the business legal life cycle. That's a concept that Craig and I have generated about when people do things well in business and when they do things successfully and when they don't. And we've come up with a system that is practical for business owners of when they should be doing things. And before and at the beginning of every one of these webinars, we talk about where this week's or this month's or this quarter's talk is relevant to the business legal life cycle. So you can see here, obviously the bankruptcy aspects of today's talk would fall into insolvency winding up. We don't have it circled, but it could also fall into the litigation dispute resolution aspects for where Craig talks about bankruptcy and where you might do that from a creditor's point of view. The asset protection side that I'm going to talk about comes into a bit about protecting intellectual property, so towards the beginning of the life cycle and the startup phase of the life cycle. So look, if you're interested to know more about the business legal life cycle, I've written a book about that, which is available on Amazon and all the bookstores, as they say. And if you've got any questions about it, we're more than happy to ask about it because it's a concept that we're quite excited about, something that we think is quite useful for business owners. And if you've got any questions about it, then please let us know. So to start off with, I'm going to, as I said at the beginning, I'm going to talk about asset protection. So I thought at the beginning of this, we should probably just set some ground rules about what we're talking about. So what is an asset? So there's a bit of literature about what is an asset. If you take the Robert Kiyosaki, Rich Dad, Poor Dad view, an asset's only something that will make you money. Now, anyone who's read that book would know that his view is that if it's your home, for instance, that's not an asset because it doesn't actually make you money. I know that there's a bit of conjecture around, in professional circles as to whether that's right. I prefer for the purposes, especially today, to look at a bit of a broader definition. And the World Book Dictionary defines an asset of something that has value. And I think for the purposes of what we're talking about today, asset protection and the like, really something that has value is much more applicable than trying to use any controversial or interesting way of defining what an asset is. So what an asset is generally the equity that you have in that asset as opposed to the debt and the value of that asset. And when we're talking about assets, we're talking about protecting things like property, real property, so houses, commercial properties, industrial properties, intellectual property. So that might be how you do things in a business, the trademarks of the business, all that kind of information. It could also be shares that you might have a business or the business itself. So when we're talking about assets, we're talking about the widest possible definition of assets. So that and when we're talking about the protection, we're talking about the protection of those assets. So the next question on this slide, and there's a little bit of a lag. I apologise with the internet for the slide to change. But what is asset protection? That's simply what we do from a legal point of view to protect that asset. So they're the basic concepts that we want to have in today for this seminar. The next slide, when it comes up, you'll see is how can a person be liable? So again, I just wanted to set some ground rules about how people can be liable. So generally a person is liable for a debt or a legal thing in action if they are bound by a contract or they're otherwise liable. So when I say otherwise liable, if you're driving a car, you don't have insurance and you cause damage to another vehicle, nearly all cars will have compulsory third-party insurance, so that covers personal injury to an individual. But if there's damage to a vehicle and you don't have insurance, then you're personally liable for that debt. Equally, if you went bankrupt, you would be personally liable. All your debts would be compromised. If you're a sole trader, you'd be liable for every single debt that's in your business. If you're a director of a company, we all know that there's certain circumstances where a director could be liable, which I'll talk about in a minute when we talk about companies. Or if you just breach a contract in your own personal name, you don't pay a telephone debt or something else, then you can be liable personally for that debt. And how can assets be attacked? You'll see that's the second question on this slide. There are many different ways. If you've got a personal guarantee, you can be sued. If you've caused damage, then from a car accident, then you can be sued as well. And also from divorce and bankruptcy. One point I'll make on divorce, and I say this with all due respect to my colleagues and other people, if anyone tells you that they can protect an asset from divorce, then they're kidding themselves or that they're talking about doing something fraudulently. The family court has very wide powers on what they can do and what they can attack from a divorce point of view. So you can set up the right structures and everything in place as best you can, but divorce is very, very hard, if not impossible, to protect from. Bankruptcy, there are certain procedures you can put in place. I know that on this call we've got a few insolvency practitioners, so they'd probably be aware of a few of those. And we'll talk about some of those structures that people have put in place. But obviously, when Craig's talking about bankruptcy, there are rules about timeframes of how when assets can be attacked for different types of uncommercial transactions. And Craig will talk about that after I talk about a few different mechanisms that we've seen used over the years to protect people's assets. So the first structure that I'm going to talk about is a trust. Now, I think everyone on this call is going to know what a trust is. And you know that you have a trustee that acquires the legal ownership, and you have a trust the trust, and you have beneficiaries who are entitled to the benefit of the property. So I'm going to leave the definitions at that. But what I wanted to talk about here was really the role of trustee. And I think it's a bit of a misconception that people don't understand that the trustee is the entity that enters into arrangements with people on behalf of the trust. Now, a trust without a trustee doesn't exist. And a trustee is primarily liable for all the debts of the trust. So that means that if you've got an individual trustee who's trading a business, as say Joe Smith as trustee for the Smith Family Trust, trades a law firm, for instance, Joe Smith is personally liable for every single debt. He has just got the right to be indemnified from the assets of the trust for that debt. Now that's why more and more, and especially when we're advising people from an asset protection point of view, that they should have a corporate trustee over that trust, because that puts in an extra layer of protection for the trust. So I think it's very important to understand that difference. The other thing is that, say if a trustee can't be indemnified out of the assets of the trust, then that's too bad. The trustee still has to stump up the cash. So what we've seen often is a trustee that might be the trustee of multiple trusts, or worse, where you've got a trustee who's the trustee of a trading entity and, say, a self-managed super fund. The trustee can still be bankrupted for the debts of one trust and still be the trustee of another. Now, if you're sensible enough and you get the right advice, you change that structure before anyone goes bankrupt. But you'd be shocked to see how many people actually have that in place. and smart business people that have been in business for 30, 40 years, just while I'm thinking one that I saw a couple of weeks ago. So it's very important that we make sure that people are aware, especially business owners, that if they've got an active trust that's actually out there trading, that it should not have an individual trustee and that it has a corporate trustee. It's best practice, I think, that for everything but passive trusts, that those trustees have corporate trustees. Now, when I use the word passive trust, just to be clear on what I'm talking about there, is to say that you've got a law firm and you've got two shareholders, and the two shareholders are simply two trusts, and that investment would be a passive investment. So you probably, in that situation, don't need to have corporate trustees. But for everything else, whether the trust owns property, whether it owns shares in other companies that it's not related to, whether it's out there trading, a trust should always have a corporate trustee from an asset protection point of view, because it's personally liable for that debt. So that's very important to have, and it's something that, as I say, comes up surprisingly often, but you guys as accountants would see it happen all the time. So if you see anyone who's personally a trustee, they should probably go and see a lawyer. We're happy to talk to them. We'll go and see their lawyer and make sure that they either change that to a corporate trustee or make sure that that's okay and they're not going to be liable for anything. So the second structure, unsurprisingly, is a company. Again, everyone on this webinar is going to know what a company is. You've got your directors who have the day-to-day control of the company and your shareholders who have the benefit of the company. From a strictly legal point of view, companies are great from an asset protection perspective. They shift liability. The problem is that more and more legislation has been changed to make directors liable. So directors, and sometimes shareholders. So directors, it used to be the case that they were liable just if they provided a personal guarantee. Then we started to have people and business owners who would not pay their debts, and they would know that their company is insolvent and start incurring lots of debts. So the government brought in insolvent trading to make directors who knew that their company was insolvent liable for their debts, which is fair enough. And slowly but surely, the ATO, as most of the people again on this call would know, brought in directors' penalty notices where directors became liable for debts that they incurred if they didn't pay say super and other taxes. That they would become liable for that, which I'm not saying there's anything wrong with that, but as more and more people try to subvert the system, the law tries to keep up with those changes and sets up more barriers and tries to pierce the corporate veil, is the term that's often used, to go after the directors. Often that won't be the case for shareholders. In fact, I'm not aware of any specific legislation that lets someone come after shareholders. But banks, for instance, are requiring shareholders to provide personal guarantees more and more where they don't have any relationship to the company itself. So companies are great from an asset protection point of view, but if you're out there doing stuff deliberately, incurring debts that you shouldn't be, not paying your employees super, because let's face it, it's their money, not paying the tax, because when we collect GST, we're collecting it on behalf of the government. We don't want to, they want to make sure that we're liable for that tax. So companies are great, but as more and more people try to swindle the system, the governments will put more and more procedures in place to pierce that corporate veil. In saying that, I would always still recommend that a business owner, either goes from an asset protection point of view with the company in trust, and then we'd always get that client to then go and speak to their accountant to make sure that the accountant was happy from a tax point of view with the structure. We're commonly of the view that the advice isn't and should never be given in a vacuum, and should always be between both parties. So I think that's an important thing and distinction to make when you're setting up these companies. So that's a company, and from an asset protection point of view, how we use those. So I wanted to just talk about property ownership, and I think the slides there we go. The slides have been a bit slow, as I said before, and I wanted to talk about joint tenants. So I'm not sure of the level of knowledge of everyone on this call, but most of you would probably be aware that you have two different ways that you can own property in Queensland. That's joint tenants and tenants in common. Now, joint tenants, when you own a property as joint tenants, you together own 100% of the property. So what does that mean? That means that if I own a property with Craig and we're joint tenants, then we both own 100% of the property, and if I die, Craig gets all of the property. Now, for that reason, you don't usually set up a property as joint tenants. you set up as tenants in common, which I'll talk about in a second. But joint tenants are usually used where you have a husband and wife who both own a property, and if one of them dies, then you want the property to go to the other spouse. That can be great because it avoids any stamp duty. The issue that you have is that if, say, you own a property with your husband and wife as joint tenants, and you what we call sever the joint tenancy, so that might happen if the parties divorce or if one of the parties goes bankrupt, the presumption is that they own the property as tenants in common and 50-50. So I'll just quickly talk about tenants in common, and then I'll just come back to that concept. So tenants in common, and you'll see on the slide we've got there, basically when you buy a property and tenants in common, you'll own the property in the percentages that you say that you own the property when you do the transfer. So we do a lot of conveyancing. When you lodge a transfer, you can either say that Jeremy Stretton and Craig Mason are joint tenants, or you could say that Jeremy Stretton owns 50% of the property and Craig Mason owns 50% of the property. Or you could say that Jeremy Stretton owns 70% of the property and Craig Mason owns 30% of the property. What that means is that in that situation, own 70% of any equity in the property and Craig owns 30% of any equity in the property. Where that's relevant from a severing a joint tenancy point of view that I mentioned before is that say that you have a husband and wife, and the wife puts in the greater share of the property to purchase the property, and then they split, the presumption is, at first principles, that they each own 50% of the property, but the wife might have put in 75% of the property to 25%. Equally, if, say, let's say the husband goes bankrupt, and a bankruptcy trustee would then take over that portion of the property, and they would sever the joint tenancy normally, and the presumption would be that the property would be owned 50-50. So you can see that there'd be a problem there if the wife had put in more money than the husband, and there'd be a presumption, they'd have to rebut the presumption of the 50-50 ownership split. So what we're seeing more and more people do is not just put the property in their wife's name or their husband's name, they're putting the property as tenants in common in, say, shares of 99 and 1. Or another percentage to better define the ownership. The reason that you do that is that often when you're doing a mortgage with a the bank will want anyone who is liable for the debt to be on the title to the property. Usually, in my experience, they don't care whether or not they're 50-50 owners, 90-10, 75-25, 99 and 1. They just want both people to be on the title so that there's some consideration that they've got. I've got someone who's here saying that I've found some banks won't allow 99-1. Yeah, I think that is happening a little bit, and I suppose it's horses for courses, and you've got to find which bank actually will do it, because there are some banks that will. We see that all the time, that some banks will, and some banks won't. But if you want to do it from an asset protection point of view, then you do that, because just to give you a practical example. Say that if I just use Craig and I as the example, and say that we have the property that we have is $100,000 worth of equity, and Craig goes bankrupt. Then, if we were 50-50 owners, then the bankruptcy trustee could come after me and say, well, we're either going to sell the property and take the equity, or you buy 50% of the property. That's fine, but if I put in more of a share of the property, then I'm not going to be very happy with that. Whereas if we did own it 99 and 1 or another percentage, if you've got a problem, if the bank's got a problem with 99 and 1, then say if it was 90-10, then the bank might come back and say, the bankruptcy trustee might come back and say, well, I want $10,000. And you can see how just setting that up at the beginning, depending on the person's asset protection and risk profile, might allow for a better distribution of the property and deal at the time, and better reflect the actual ownership of the property if something happens to that person. So that's property ownership and the different types of property ownership. There are things, one of the things that we've seen more and more happen too is where people buy a property in their wife's name, and that the husband's the one contributing all the money, and I use husband and wife because there's a bunch of cases in Sydney where this exact thing happened, where barristers would incur all these great debts, and the courts are more and more finding that the wife owns that property as constructive trustee for the husband, and if the husband goes bankrupt because they haven't paid their debts, then coming after that. So that's just another case of the law trying to catch up, or not trying to catch up, but catching up with people who are trying to do the wrong thing. But there's many different ways of owning property, and we can help people with any of those things. The final thing that I just wanted to talk about before I hand over to Craig, and this is a bit of a mechanism that people use to protect equity in their property. Now, I'm going to say at the outset that, and Craig will, and people on this call will be aware that there are many mechanisms in place to prevent you from doing this at the 11th hour. So you don't look at doing an arrangement like this when the person's in financial trouble. If they're in a good financial position, then they can look at doing something like this, because otherwise, if they try and do it beforehand, just before they're going to go bankrupt, and Craig will talk about the timeframes, but it's easily going to be wound back very, very easily. So basically, the concept is a gift and loan back arrangement, where Fred, we'll use Fred as an example, owns a property with $2 million worth of equity. He sets up a trust, and let's wait for that slide to come up, and he gives the $2 million to that entity. Very simple transaction. The trust then loans the money back to Fred and takes a mortgage over the property. The advantage of this is that it gives the trust a registered interest over Fred's property in case something happens to Fred. There's two downsides to this. One is, quite clearly and understandably, the structure could be overturned if it were an uncommercial transaction or an undervalued transaction, and all the stuff that Craig will talk about with bankruptcy in the future. But also, it only protects the equity in the property at the time of the loan. So say that Fred does this today, and it might take 5 years or 10 years or whatever for him to be in the clear from any uncommercial transactions. The property is probably going to increase in value for over that time. So say it's worth $3 million. Any equity over and above, say that there's equity in the property of $3 million. Any equity over and above $2 million isn't protected. And if you wanted to protect it at that stage, you would have to then protect it. Now, the reason I'm raising this is that I know that a lot of my clients, and who has been on these calls, would know that we work with a lot of accountants, that a lot of people have been doing some seminars and talks selling this kind of product. And at least the people that I've spoken to haven't understood those risks. And we're very upfront. We always want to make sure people understand the risks, that if they or their clients enter into these arrangements, it's going to take a long time before it's actually going to mean anything from a strictly legal point of view, and that you need to be fully aware of the risks of what you're entering into. There's no silver bullet that can protect someone forever, but it's about putting structures in place that, as best you can to protect your clients. So if anyone's interested in instructions like that, I've gone through that pretty quickly, but I'm happy to talk about it further. But we're already probably past my time for talking, so I'm going to hand over to Craig. Once again, if you've got any questions on any of the stuff that I've talked about, please throw them into the question box, and I'll happily answer them at the end. And Craig's also happy to answer questions as he goes as well through his talk. All right, so I'll hand over to Craig.
Afternoon, everyone. Thanks, Jeremy. As Jeremy said, I'm going to talk about bankruptcy. Some of the stuff's common to you guys, and you probably know it back to front. So bear with me, but I'll just go generally through bankruptcy. So obviously, what is it? Well, it's simply the legal process where a trustee is appointed to administer an insolvent person's affairs. And the objective of it is to provide a fair distribution of the person's assets. The Bankruptcy Act, is around to protect both debtors and creditors. The debtor obviously is protected in the sense that they can't be pursued anymore by most creditors, and they're given basically a fresh start after the period of bankruptcy. And it protects creditors in the sense that now, instead of the debtor running their own affairs, there's a qualified accountant, independent, that's now controlling their assets, and they're going to collect the assets and then distribute the bankrupt's assets accordingly. We've just got a question. We might.
We'll do it at
the end.
We'll do it at the end. Yeah.
And in terms of bankruptcy, so how it can actually occur, there's two ways. One is through a debtor's petition, which is self-initiated. So the bankrupt basically does it themselves. They file a debtor's petition and a statement of affairs, and then upon acceptance of that, and they get a bankruptcy number, they're now bankrupt. Or the other way is by way of a creditor's petition. So that's obviously, the name gives it away, that's initiated by a creditor. The normal process for that is that there's a court judgment. There's then a bankruptcy notice that's filed with the Australian Financial Services Authority, and then that's normally served on the person, and they've got 21 days to either pay the debt or make an application to set aside the bankruptcy notice or whatever it might be. And if they don't do anything within those 21 days from service, they've committed the act of bankruptcy. And it's at that point that a creditor can file with the Federal Circuit Court a creditor's petition, along with a number of other documents, including a consent from a trustee. So in the situation with a creditor's petition, the creditor can request from a trustee the consent, rather than with a debtor's petition. There's no control over who the trustee is going to be. And then you file the documents. It's quite a costly process from a legal cost point of view. The filing fee has been raised quite considerably to what it used to be, and so now you're looking at sort of $6,000 to $7,000, including professional fees and various other things to proceed with that. And obviously the debt that you're owed has got to be over the threshold, which is currently $5,000, in order to even start the process. But that's the way that you would bankrupt someone, and then the trustee takes over and they go from there. So the trustee powers, obviously the main one is that they sell any of the property that's available to them. They're going to investigate the affairs. They may, depending on the attitude of the bankrupt, have to examine the bankrupt and others under oath, and you've probably seen that in the news at various times with various high-profile bankrupts and ex-politicians and sport team owners. If there's a business, they might be conducting and continuing the business and sell the business. They go through the process of admitting the debts, so any creditor would be lodging a proof of debt. The trustee would be going through that and, if accepting it, admitting those debts. And obviously, if there is any funds at the end, then they're going to be distributing those dividends. And throughout that process, of course, as well as there might be some recovery action against various parties to recover monies that are due and owing to the bankrupt. And just further with bankruptcy, most debts are covered in the bankruptcy. That's both secured and unsecured. There are a few exceptions to what's not covered. That includes court-imposed fines, penalties, that sort of stuff. Child support. It doesn't include your HECS or your what's now known as HELP debts. It obviously doesn't include debts incurred after the bankruptcy begins. And during your bankruptcy, you can continue to earn an income if you can, and there's thresholds that have been developed as to how much you can earn before the amount over and above that goes back into the bankruptcy. They're currently sitting at, if you have no dependents, and this is after tax and Section 139 and deductions, which is child support and those sorts of things. If you had no dependents, you can earn about $54,000. If you had one dependent, about $64,000. Two dependents, just over $69,000. Three dependents, $71,000, almost $72,000. If you had four dependents, just over $73,000. And if you had five or more dependents, then it's up to just over $74,000. So you can earn up to that. And then after that, the income's coming back to the trustee. So 50% of the income over and above those thresholds are going back to the trustee. In terms of how long bankruptcy goes for, well, a person's undischarged until their bankruptcy is either finalised and discharged or annulled, and it's currently 3 years from the date you file your statement of affairs. That period can be extended to up to 5 years by the trustee, and the main reasons for extending it is obviously the bankrupt's not cooperating with any of your requests, not lodging, not providing the statement of affairs, or leaving the country without permission, or engaging in some misleading conduct. It might be over getting credit, or not disclosing that you're bankrupt when getting credit over a certain amount. So in those instances, the trustee can extend the bankruptcy for up to 5 years. So during the actual period of bankruptcy, you cannot act as a company director. You can't trade under a registered business name without advising the outside world. You obviously have to make all your assets available, hand over your passport, and then you need obviously to obtain permission to travel overseas. Again, that's comes up in the news quite a lot with some of the high-profile bankrupts wanting to go overseas to go to job interviews in New York, for instance, or Hawaii for a holiday. But there's a certain amount that if you're incurring credit, you need to disclose that you're bankrupt, and that's currently about $5,500. If you're seeking credit over and above that amount, you need to disclose that you're a bankrupt. And if you don't, then that might be one of the reasons why the bankruptcy might be extended. In terms of bankruptcy as well, there's a motor vehicle allowance of about $7,700, and there's also tools of the trade that you're able to retain, and that's at about $3,750 at the moment. So that's generally bankruptcy and what you can do and what you can earn. And then the two things that come up, and this is where it relates to your asset protection that Jeremy's been talking about, is void transactions and preference payments. So as I said before, one of the trustees' responsibilities or powers is to investigate the affairs of the bankrupt, and included in that is any pre-bankruptcy transactions that may have been improperly done to transfer assets away from the bankrupt, so they won't be available to obviously to pay their creditors. And so the Bankruptcy Act, obviously, when they were drafting it, realised that these sorts of things happen all the time, so they've put in sections to void transactions. And there's basically three types of transactions that can be voided. One is undervalued transactions. The other is transfers done to defeat creditors, and the other one is where the consideration is paid to a third party rather than to the bankrupt. So the big one with undervalue is obviously selling a property to someone under the market value, and you might see occasionally someone might sell their house to their spouse, for instance, for $1. Pretty obvious that that'd be less than market value unless it's a shanty somewhere that's only worth $1, but that'd be very unusual. So that would obviously be less than market value. The other one is you might purchase something that's at a greater consideration than what it actually is worth as well, so therefore transferring more money to someone else and getting an asset that's not worth much at all. And so these types of transactions can be voided if they've been done 5 years prior to the bankruptcy commencing. Now, there are ways to protect these potential void transactions if the following is satisfied by a person. And they are that the transfer occurred over 2 years prior to the commencement of the bankruptcy. Transfer did not involve a party related to the debtor or the bankrupt. and the big one that Jeremy mentioned before, the fact that they were actually solvent at the time of the transfer. The 2 years is extended out to 4 years if it's a related party. So if you satisfy all of those things, so not just one, you have to satisfy all of those, then you might be able to protect that transaction that occurred. And the thing is that the trustee actually has to refund the consideration that was received in order to have the asset transferred back as well, which obviously would prevent a lot of these things actually happening. And the trustee's got 6 years to commence these proceedings to void a transaction. Chris has just put just worth mentioning, super contributions made to defeat creditors as well, so that could be void. So that's Chris. Thanks for that, Chris. Good comment. The other one that I mentioned is to defeat creditors. So obviously the intention of that is to reduce the assets, then meaning that there's not as much available to give back to the creditors. Again, if you've satisfied various things, you can have that not set aside. Those sorts of things are, the consideration is market value. The big one with this is that the actual person had no knowledge or could not have reasonably inferred that the bankrupt that's why they were doing it, and that there was no knowledge that they could have been insolvent or about to be insolvent. And if they involve fraud or dishonesty, then it's whenever the trustee basically finds out about those things that they can commence those proceedings. There's no 6-year restriction as per the undervalue. And then the last one was the third party. So that's where a third party receives the money that should have gone to the bankrupt. Again, there are protections. It's got to be before the bankruptcy. Again, unaware of what's going on. And then the burden with all that rests with the person that's trying to maintain that. The other thing that comes up quite a lot is preference payments. This again is where a payment's been made to creditors that gives them advantage over the other creditors. And in terms of a preference payment, the transfer or the payment must have occurred within 6 months of the date of the creditor's petition or the debtor's petition was presented. Again, there are defences to that, and there's 3 of those. And again, similar to undervalued transactions, you ought to maintain all 3 of these. That it was in the ordinary course of business, that the person that received the money acted in good faith, and that valuable market consideration was provided. So the good faith one's probably the one that people would fall down on mostly, and Chris has made the comment before, would probably see this all the time, but good faith, if you've instituted proceedings or stopped credit or done any actions that is clear that that they're either struggling or not paying, you're going to struggle to maintain the acted in good faith. So if you've instituted proceedings, then you probably forget about it at that point. And these claims must be made within 6 years after the bankruptcy commenced. Now, we've just got a question there about what to do if a client receives a letter from a trustee about preference payment. Obviously, a couple of things you need to check. Obviously, not that the trustee may have got it wrong, but check anyway to make sure that it actually happened within the time frame of the 6 months. If you're a secured creditor, then it doesn't apply. Was it actually a payment? It wasn't a cash on delivery situation or something like that. And that there needs to be that there was actually an advantage over other creditors, which would be relatively easy to maintain. But I guess the advice is that if you do get one of those letters, that you look into it, and there might be a defence available to you. Head in the sand at that point, it may not be the recommended course, but seek some advice would be the advice there. So that's void transactions and preferences. The last thing I just wanted to touch on is an annulment of your bankruptcy or a Section 73 proposal. So annulment is where the trustee obtains sufficient monies to be able to pay all the debts, including the trustee costs. Everything's paid. An annulment means that it didn't happen. The other way is a bankrupt might convince a court that it shouldn't have happened or should never have been commenced. That's a pretty hard argument to run. It's normally about service or something like that they didn't receive the documents, but it doesn't happen that often. And the other way is what I said before, a Section 73 proposal, which is where a bankrupt, through the trustee, proposes to pay a certain amount to the creditors. There's a creditors meeting, and that proposal is voted on. There's certain a majority of creditors and amounts of the debts that are owed that need to be present and vote. And then if it's voted on and it's agreed, then the bankrupt will be paying a certain amount, and then their bankruptcy will end at that stage. And once it's satisfied, so they're the ways to get or to finalise a bankruptcy or to no longer be bankrupt. And then the final thing is there were some proposed changes that may have come in that Prime Minister Turnbull was talking about at some stage about changing the Bankruptcy Act. A few of those changes that were proposed were reducing the 3 years down to 1 year, and implementing a safe harbour for company directors, so provided they've engaged a professional restructuring advisor. So that's going to bring a whole new regulated industry to that, where you have to be an actual qualified restructuring turnaround solution person. And the other one was banning clauses in some contracts where if one party has the power to terminate if any form of insolvency event occurs, and they're going to ban that provided you are again engaging in some form of restructure or speaking to a restructuring expert again that needs to be a qualified and a registered one. Who knows if any of these changes are actually going to occur, and what ramifications they'll actually have. My thoughts about 3 to 1 year and not being so severe on a bankrupt is that does it really take into account the fact that the flow-on effect from one person going bankrupt can tend to affect other businesses that are owed money, but time will tell whether to actually make any of these proposed changes. So that's what we wanted to cover today. Is there any other questions that anyone wanted to ask?
Well, I've just got the one, Craig, that Stephen asked just after you started. So this was just going back to the discussion that we had about the gift and loan back, and Stephen asked, how is the gift documented? Is it sensible to exchange cheques or other forms of payment for the $2 million? If you've got that kind of cash, then yes, that would be the way to do it. Most people, in my experience, don't actually have that cash to be able to pay the money to do it. So that's why it would form into potentially a void transaction or a preference payment, or one of the ones that Craig talked about, undervalued transactions. So ideally, it wouldn't so much be it wouldn't be so much a problem if you could come up with the physical cash. But the way that we document it is a deed of gift and loan, a deed of gift and a deed of loan, and mortgage. And the gift is literally gifting the equity that you have in the property. So one question that we've been asked previously about this is, can we cover off on all of the future equity in the property? And the answer to that is no, because you've actually got to prove that you have that equity at the time that you enter into the transaction. So normally we'd get the client to get a valuation of the property, work out what their debt is, and then then you'd work out what the equity is there. So so they're the main things. There's a couple more questions. one question was, when does a trust come to an end? If you're talking about just, and Chris, thanks for the question, but if you're talking about just a normal discretionary trust, they've got a period of 80 years. So the law says that if a trust goes for more than 80 years, then it automatically ends. So if you've got a trust that comes to an end at that point, normally though it would come to an end by it being wound down. So if the trust no longer needs to be used, normally we'd actually do up a deed of termination. So most trusts will contain a clause that says if you're going, the appointor or the trustee or even the beneficiaries in some cases, in some of the ones I've read, wishes to terminate a trust, then they have to follow a procedure, and there's a procedure usually set out in the trust deed, and you'd follow that procedure, and you usually do that by a deed that's just done, and then it's documented with the trust. You'd make sure that all the assets are out of the trust, you'd make sure that all its taxes are paid, and then the trust would come to an end, and any property, any income, any money, or any assets that the trust held would then be distributed to the beneficiaries in accordance with the trust. So normally it will say that it would go to the default beneficiaries or the primary beneficiaries, or it would have some sort of procedure in there. So that's when a trust would come to an end, usually either 80 years or when the parties determine it. And Chris has got another question for Craig, so I'll let Craig do that.
Question is, a corporate trustee falls into liquidation and creates a bare trust. How is this rectified?
What do you mean by, it probably needs a bit more clarification, Chris, if you're able to put that up there. We'll wait for Chris on that one. And Chris, if you want to just email us, we're happy to get into a bit more detail. As we said at the beginning, there's a picture of us and our contact details. So please feel free to contact us if you've got any other questions. We're happy to answer them and happy to look at what we can do to help you guys and make sure that your clients don't get stuck in any of these problems. If there's nothing else, I'll say thank you, and as I say, send us any questions that you've got. And Chris, if you want to just clarify that one with a question, that'd be great. And Craig?
Yeah, thank you everyone for your attendance. As Jeremy said, send through any questions or any other inquiries about anything. Thanks, Chris. Yeah, good work. Thanks, mate.
And we'll also, as we do normally, we'll take a recording of this, and we've made a recording of this, and we'll send that around for you guys with a Dropbox link in either this afternoon or tomorrow. So thanks very much, and we'll speak to everyone later. Cheers.